topic is about the most hot topic in the area of legal fraternity as of now. But slowly technology fraternity is also trying to catch up with the trend, which is nothing but our Digital Privacy Act, which is recently enacted in Parliament. So we have a special guest Murli from Deloitte, who is going to give a high-level overview about what is this Privacy Act about, how it is going to impact us, how organizations can able to start it out. And also, I would be covering a short session on how SAP as a technology provider would be able to cater, as of now, the top two to three solutions which could able to immediately help you in addressing the high-level requirement of digital privacy. Okay, why we are saying this is since it is already passed out as a law, but it has to go through a cycle of regulations, plus also what to do, when to do, who to do. So a lot of things are happening. It will take their own time. But there are a lot of customers who are keen to start the technology implementation right now. So we, in that front, we are going to give a high-level view. Okay. Thanks once again. Over to you, Murli, for the next 40 minutes. Please feel free to ask the question and answer. I would be available in the chat window as and when any questions. Happy to address it, or post the session. We could also have a Q&A session. Thank you.
Thanks, Srinath. And then we can
yes, we could see the
screen.
Thank you. Could you please be louder, Murli?
You hear me better now?
Yeah, perfect.
Right. So very good morning. My name is Murlidhar. I'm from Deloitte, as Srinath introduced me here. So today I'm going to talk about the Digital Personal Data Protection Bill that is passed in 2022 and 23. So I'm going to quickly take you through a couple of items in the next 35-40 minutes. How data privacy came into India and how we started off and etc. We have a couple of milestones that we captured. What is this act about and where it is applicable? What are the key roles and what are the applications that we need to be adhering to, and the basics of the Data Processing Act? What are the rights that one should have, and special provisions, penalties, of course, and then way forward for the readiness. So, okay. So, this is about the history, how data privacy started in India, right? So we were almost the first to start off with a data privacy bill in 2016, while the GDPR started in 2014, right? But then things did not start as planned. But then we had a couple of things that was started in 2016, and then we had the amendment in 2007, where it's only about the IT Act. In 2011, where it actually started taking a little bit of a shape and form about implementing the IT Act with dealing with the data protection. And in 2017, we started off with the constitutionally protected rights, which were supposed to be guarantee of life and personal liberty, which is part of the Article 21. In 2018, the draft was submitted. In 2019, the bill was passed only for the Aadhaar card and some other laws, which is very brief. In 2019, we had the DPDP revised draft that was submitted in Lok Sabha, and it was jointly passed for the examination. In 2022, the initial draft that was submitted was withdrawn, but then the DPDP, that what we're talking about today, has been passed, right? So after the bill is passed, what are our challenges? So we still have to set up the Data Protection Board of India, which is not formulated yet. So we still need to look through the enforcement of the act. How are the organizations going to respond and how is going to take it, right? So we will talk about the DPDP Act now. So overall in the act, so we have 9 chapters that are mentioned, which has 44 different sections that we'll talk about what is this, what is privacy, what is data that we're collecting, how we should process it, who is responsible, right? And then there are 4 rights that are specifically called out to process the individual information, which is right to access information about the personal data, and right to correction and erasure of the personal data. So that is something that is needed. A right of the grievance redressal, if there's any data updations, correction that needs to be done. So there should be a communication, sorry, there should be a communication channel to address them, and right to nominate. If there's somebody who is um, passed away, and who has to take the data ownership, right? And then penalties come up to is the maximum penalty that we have listed on in the act is about 250 crores. Um, there are a couple of items that has been mentioned. One is failure to prevent the data breaches. If there are data breaches happening across the organization in the multiple formats and shapes, there is a penalty. Failure of the notifying data breaches. If there's a data breach that has happened and it is not notified to the concerned um, authority, then you will have a penalty. Non-fulfillment of the additional obligation in relation to the children, which is the right to correction of the data, or right to erasure of the data, or right to access of the information to the by the respective parent, will be penalized. And non-fulfillment of significant data fiduciary obligations. Any data that has been shared between the trustee and the data owner, if there are any data requests that has not been fulfilled, so it will be penalized. Non-compliance with the duties of the data principal. The data principal is the person who will have a certain responsibilities to fulfill on the data privacy on the data request that needs to be fulfilled. If there is any deviations with that, will be penalized. And non-fulfillment of any voluntary undertaking given to the board. So as I mentioned, the board is not formed yet, but there is anything that needs to be submitted voluntarily about the data breaches, etc. So that will be penalized. The obligations to that is the data fiduciaries, significant data fiduciaries, which is the marginal data volume exchanges between the parties, the data principals. So I'll quickly take you the summarize of the act, right? So I was just talking about the data principal. I was talking about the data fiduciary. So I might be wondering, who are these people, right? So an individual is the data principal, whoever is providing the data for the organization to process it further for their purpose. So that would be a data principal, which is an individual. Organization is the data fiduciary, who would hold the data, who would store the data, who would process it. So they would become the organization as a data fiduciary. Agents of the organization, that is the data processor, which could be part of the organization, or which could be outside the organization, which could be your third parties who would process the data, considering you may have some service providers who would process the data. And regulatory body, that is our Data Protection Board of India. So that would govern what is the data that you would be storing within the organization. And there are 9 key pointers that would cover as part of the Digital Personal Data Protection Act. Specifically, to start with is the privacy notices, policies, and procedures. Any information that you're collecting through the within the territory of India for the people who are staying within the organization, sorry, within the country, all the websites or all the portals that you will be collecting information should have the privacy notices, the policies, and the procedures listed down to the individual, so that one individual can read through it, and then they can consent for the data that should be collected and stored in the organization. Lawfulness and consent management. All the data that is being provided by the individual should be legally correct. For example, if I am saying and I am consenting for the marketing communication today, and after a week, I will come back and say I'm not consenting for the marketing communication. So the change of the data subject should be lawfully updated in the system. And the consent and their preferences. For example, if I have to receive the marketing communication by 9 a.m. For and I should be receiving the call right my preference and not any other time. And the data principal rights, all the data that is being stored for the data principal, for example, is right to update, right to correction, right to erasure. All those data principal rights should be properly managed. Design and implement data management. So we understand the data might be stored in different repositories, or it might be stored in the master repository, but the consent part of it, or the cookie part of it, or the preference part of it should be clearly stored inside the data management. If there are ways which you need to improve in order to store all of this data, then that is part of the piece. So you have to design the database system to ensure all the data subject rights and the data fields are appropriately collected. And powers of functional and the Data Protection Board of India. So there are certain roles that we need to have within the organization while we are approaching to the Data Protection Board of India. So I will talk about that in detail. Who are those people? What are those key roles? Then the security controls and technical limitations should be overcome with respect to any of the data that you would be processing within the system. And the grievance mechanism, as I mentioned, if there is any grievance with the data that has been taken already into the system, if there is any data updates or any other grievance mechanisms that needs to be worked out, it should be properly vetted. And the audit and compliance, any audits that will be done either internally or by the external vendor, all those audits should be properly managed, and the audit logs for each of the data subject should be appropriately maintained in the system. The last one is the governance and the penalties. As part of the Data Protection Act, so there are certain governance bodies who should be formed within the organization. For example, the DPO, and who should be the data processor, who should be the owner, and etc. So the governance should be formed. And when responding to the grievance or when responding to any of the penalty, who should be approaching to the board, etc. So that governance has to be come through, and the penalties, as I mentioned earlier. Okay, I'll take a quick pause here and then ask if there are any questions that you have so far.
Hi, Murli, Srinath here. On behalf of probably others also, it's a short question. How far this Privacy Act is been globally, there is any global emulation? I'm sure we all know that GDPR is one side. How far our Privacy Act also is getting impacted from other country regulations?
So, Srinath, for India, it is only for the data which is collected and stored within the India, right? So we're not looking at any data which is stored outside our India for the people who are, the Indian residents, right? To answer your question, starting from the GDPR, so any data that is, or any regulation for that matter, whether it is a Nevada Act or whether it is a CCPA, which is a California regulation, so they want to protect their employees' data, their citizens' data, making sure that the data is protected. So for India, it is net new. As I mentioned, the concept is not new, but the Data Protection Act is definitely is taking place. And while we look at the market, for example, the life sciences, healthcare, or while we talk about the consumer industry, it is actually taking a shape and form very rapidly, and everyone is concerned about the data protection, right? Because today there are people who go to the social media application, they find out how to request for their data, right? There are information that is already available, so people are really responding to the Data Protection Act. And how soon it will take in shape and size, possibly in the next 1 or 2 years. Even the Data Protection Act, I will talk about this. So we have been given at least 5 years to ensure the data is uh, precisely maintained within our database systems, and all those grievances and everything that is taken place. For example, the data management, etc., is taken care within that 5 years. So we have been given that time.
Thanks, Murli.
Okay, quickly moving on. The applicability of this act, right? So the act is aimed at enforcing the data privacy only in India. The conditions that we have is applicable only for collection of data within the territory of India, as I mentioned, where the data is collected in digital form, or where the data is collected in non-digital form and digitized subsequently. For example, it could be your Aadhaar card updates, or it could be any other information that is collected through the offline channels, and but then it is digitized later. The Act applies to the data and processing of the digital personal data outside the territory of the India. If such process in connection with any of the offering goods or services to data principal within the territory of India. For example, if there's any data that has been collected and processed within India, but then you are sharing that data outside the India for any of the business purposes, so that should be governed, and the Act applies there. The personal, what are the exceptions here, right? One is personal data processed by an individual for any personal or domestic purpose. For example, if you go to the retail outlet and you're sharing any of the information just for that transaction, and you're not storing any of the data, so then it is not applicable. Personal data made public by data principal or any other person, which is um, any data that you would share publicly, without with the voluntary consent, not by the force or anything. So that is not applicable. So this is where the data is not applicable. So we talk about the key roles. Um, there are 6 roles that we need to really look at. One is the data fiduciary. A person is in conjunction with another person, determines the purpose and meanings of the processing data. So which is an organization, as I said, whoever collects the data from the individual and process that information becomes the data fiduciary. Data principal is an individual who would the data belongs to and who would provide that information to. If individual is a child who is a minor, then their parents or the lawful guardians of that child are also considered as a data principal. And similarly, if there's any individual with a disability, the lawful guardian or the person who is acting on behalf of the individual are also considered as the data principals. The data processors, who refers to any person who process the data on behalf of the data fiduciary. For example, um, as I mentioned, if there is an organization who would process its own data, uh, because I worked within the some of the application that is developed by the SAP in the past. So SAP has a very good database monitoring system. You would have some of this data that is being processed within the organization. But for the other organization, let's say if it is a startup, if it is a moderate organization, not a very large organization, if they have some third parties who would process the data, who would become the data processor for them. Data protection officer means an individual who is appointed by a significant data fiduciary as per the provisions of the Act, undertaking activities assigned within the Act. So the DPO role is specifically called out in the Act. So we need to appoint a DPO basis, the organization size and the volumetric of the data that is being stored within the organization. Okay, so it should be the person within the organization, not outside. Data Protection Board of India is responsible for the receipt of complaints, formation of the group of hearing, pronouncement of decisions, and other functions as mentioned in the Act. Any grievance redressals issues, any non-fulfillment of uh, request, any data fiduciary issues, etc. If there's any complaint that it is raised by the data principal or by the data fiduciary reported for the data breaches and etc., should be reported to Data Board of India. The significant data fiduciary means the data fiduciary or a class of data fiduciary may not be notified by the central government, but the criteria is not criteria is notify the significant fiduciary includes a volume of sensitivity of personal data that is being processed, which involves any risk to the rights of data principal or the security of the state or the public order. So I'll quickly dwell into some of the data fiduciary or the significant data fiduciary and the principles. Um, from a data fiduciary standpoint, as I mentioned in the beginning, the lawful processing of the data is very important. So that is detailed called out in the section 6 and 9 of the Act. Notice and consents should be issued in the public interest and comply with the Act and maintain accurate personal data and then implement technical and security controls to manage this data accurately in the system. Any data breach notification, any data loss and prevention should be accurately notified. Data retention and disposals should be maintained. Publish business contact information of their data protection officer for any of the questions that they may have in terms of the data that is being processed. Respond to the data principal right request. Any right to erasure or any right to update should be addressed. Appoint a data processor under a valid contract. So if you have your own data processor, you don't need to worry about it. If you don't have your data processor, then you should have a valid contract that is signed with the third-party vendors to ensure the data processor is responsible for it. Erasure and cause the data processor to erase personal data when the data principal withdraws a consent. This is again right to deletion and the data retention policies applies. So let's say if the data should be retained within the organization for about 5 years from the time, irrespective of the consent changes, other than the right to delete request, you should have the data maintained. If there is a right to delete request that is triggered to the organization, then the data should be deleted and the confirmation should be sent to the individual. Establishment mechanism to redress grievances of the data principals. You should have the proper communication channel to address any of the data grievances, either present in the portal or any other forms of the communication that you might have. Publish the business contact information of the data protection officer. Again, this is something that we would put across the website wherever we have the privacy notices or the right to contact informations, etc. Refrain from processing data that may cause harm to a child or track them or obtain parent consent before processing. For example, you might be aware today there are multiple schools or the educational organization are tracking the data in multiple forms and shapes. So whether the parent is consented, if it is being harmful or if it is being tracked for a different purposes, then it should be um, taken care. Either it should be withdrawn or it should be consented by the parent, right? The significantly data fiduciaries, all obligations of the data fiduciary would apply. And to support any of the data processing within the organization as part of the data fiduciary, you should have the data protection officer who would overlook the data that is being processed in the organization. Again, for an audit and compliance perspective, we should have an independent data auditor who would look at the data that is being stored and being audit trailed for every action. Undertake data protection impact assessment to ensure the data protection violations or any data protection breaches that you may have is taken care. And then perform your periodic privacy-based audits just to ensure that the data is uh, up to date and there's no deviation. Just to ensure that you are submitting any of the information that you need to voluntarily submit to the Data Protection Board of India. And the next one is the data principle. So we talked about the data principle, right? So the individual. So in terms of the child, so we should always, we always look at the guardian or their respective parent as a data principal. If there's somebody who's impersonating as the data principal on behalf of the child or as another person, so that should be very well actioned and taken care of. Comply with the provision of all the applicable laws within the organization and as provided in the Data Privacy Act. Do not register any false or frivolous governance compliance with the data fiduciary or the board. This is for the individual. One can say, I have submitted for the grievance reversal and this is not done. So for all that, they must provide the valid information. They cannot just put a false complaint over there. And do not suppress any material information. If there's anything that is mentioned as form of the pictures or anything, so that should be properly shared with the Data Protection Board. Furnish only verifiably authentic information. This is exactly what I mentioned while they are registering the grievance complaints. So quickly moving on to um, so basic of the processing information that is a consent, right? So we all talk about the consent, which is a very clear language, which is freely given, specific and informed, and an unambiguous indication of the data principle wishes through the affirmative action. What is the consent? So while we're talking, if you are taking any of that information that you are abiding to, either say receiving the marketing communication, sales, newsletters, etc., you are providing the consent, as in you are agreeing to terms and condition to get those relevant information, right? Consent request must be raised via notice and must be represented very clear and in a plain language. There should not be any jargons that is or the legal terms within the document, so that one should not feel that they would not understand it, right? The option to access the notice in English or languages specified in the 8th schedule of the Constitution must be provided. The contact details of the PDO, DPO should be present if it is applicable, or an authorized representative should be included in the notice. So typically in a GDPR, if you have seen, so we have we have always been providing the data protection officer or the chief privacy officer information there, just to ensure that there are questions that is arising, so they would be able to contact them. The OC also focused on the right to withdraw consent and ease of withdrawal. It shall not affect the lawfulness of processing at any point of time. It also has made a small room for the consent manager as a registered entity to give, manage, review, and withdraw consent on behalf of the data principal. This has not taken place yet, but then this would come very soon. What are the key features in the notice that we need to look at is the fiduciaries at the time or before collecting the personal data, and it must provide description of what personal data is collected and what purpose. And data fiduciaries must furnish an itemized notice to the data principals regarding previously collected personal data under the new act. The new notice should detail the collection of data against what is being collected and the processing purposes very clearly in the at the data collection itself. The notice must explain how the data is being processed, how data principal can exercise the data rights and file complaints with the board. Additionally, the data fiduciary must offer the option to access the notice, either in English or the languages listed. So if you want to take a look at some of the examples, so I would encourage you to look at any of the GDPR laws that is already been published in your respective portals, or any of the California Privacy Act or the Nevada Act, or any other acts that were applicable to you in the respective countries. Considering SAP is a the multinational organization, you can just look into some of the privacy notices, and this is just that. Certain legitimate uses for voluntarily provided personal data with a valid exception, as I mentioned, for performance of any function under the law, for medical emergencies involving vital interest on the public health, one can share the data, for taking measure to ensure safety and public order, for certain purposes related to the employment, the data can be processed. The following for the compliance and judgment order issued under Indian law and compliance with order of contractual civil nature issued in any foreign law when you are exchanging the data. Sorry. We'll quickly talk about the right of the data principle. Under this particular act, the data principle has a couple of rights. One is right to access information about their personal data. Again, individual can request right to obtain confirmation of the processing of the data, summary of the personal data being processed, and identifies all the data fisheries processing of the data. And the right to grievance redressal, which is mentioned in the section 3. Any grievances that needs to be addressed, so you can register a grievance and then that should be processed through. Right to correction and erasure. The data principal will have all the rights to correct their data and erasure of the public information, which includes the correction, completion, and updating the personal data. And the right to nominate, as I mentioned, in case of death or incapacity of data principal, they have a right to nominate any other individual who can exercise the data of the data principles. So these are some of the act that the individual has. So what are some of the things that are allowed as part of the rule when you're processing the data outside the India? Data transfers are allowed to any country or territory outside India. However, as I mentioned, as per the section 16 of 1, the central government may, by the notification, restrict the transfer of the personal data by a data fiduciary for processing such a country or a territory outside India is notified. For example, if you are transferring any of the data to the embargo countries, for example, it is prohibited. Additionally, if there's any data that is going through any of the countries that are not listed to transfer data outside India, so it's also been restricted. Additionally, the Act allows applicable of the sectoral laws that provides high degree of protection or restriction of the personal data that is outside India. So when you're, this is again for the data part for the data protection. While you are processing the data, you should mask the data and you should classify the data in a appropriate manner to ensure the data is not being exposed to the public or to the cyber criminals. Okay, so we'll quickly talk about the exceptions. So there are 3 exceptions. One is our general exceptions. Second is special exemptions, and the third one is the central government and states, right? General exemptions are very specifically about enforcing the legal rights and claims while one processing the data for court and legal proceedings, law enforcement and investigations. The data can be shared for processing of the personal data and data principal for the contract outside India, For compromise, arrangement, merger, amalgamation, reconstruction, transfer, order by the court. For ascertaining the whereabouts, financial information, assets, liability of the creditor. For example, it could be as simple as the credit score. Examples, exempted obligations under section 17(1) is data principal rights and duties, processing of the data outside India, which is not considered here. And the special exemptions are the volume of the data being processed within the organization, the nature of the personal data that is being processed, the data accuracy and the erasure, notices, processing of personal data and children, right to access information about the personal data. These are certain exceptions that we have. And exemption for the court, exemption for the central government and states that we have is data erasures and corrections that is listed for the government and public usage. For any instrumental of the state, government may notify the interest of the sovereignty and integrity of India, security of the state, friendly relations with the foreign states, and the public order. So we'll quickly run into the non-compliance penalties. As I mentioned in the beginning, so the penalty for the failure of this act is maximum of 250 crores. There are 7 places where they mentioned, where they will be penalized. One is penalty for failure to protect a data breach, which is 250 crores. Notification to the board and data principal, failure to notify the board and data principals in the case of a data breach, which is 200 crores, a maximum up to. A children's data, non-fulfillment of obligations while processing the children's data, which can be penalized up to 200 crores. Significant of the data fiduciary, non-fulfillment of the obligation when the government notifies significant data fiduciary, which can be penalized up to 150 crore. Non-compliance of the duties of data principal up to 10,000. Voluntary undertaking, breach of any voluntary undertaking accepted by board, penalty up to the extent applicable for the breach. And miscellaneous non-compliance with provisions of this act, other than those listed in the general exceptions or the voluntary undertaking, can be penalized up to 50 crores. So some of the highlights of the data protection bill, right? So the Data Protection Board of India ensures compliance. The composition of the board and its establishment shall be determined by the central government. As I mentioned, this has not been formulated yet, but there are a couple of functions that were listed in the law. One, to receive the compliance and pronounce decisions. That is the function of the board. To determine the non-compliance and impose penalties. To allocate work and forms group of hearing by the individual or by the data fiduciaries. To issue directions for hearing and modify, suspend, withdraw, and cancel them. To direct the data fiduciaries to adapt certain measures in case of a data breach. Alternate dispute resolution. The board may direct parties for alternate dispute resolution where it deems fit between the individual and the data fiduciaries. They will also help review an appeal of the request. The board may review its order for reasons to be recorded in writing. The appeal against the order of the board shall lie within the telecom dispute settlement and appellate tribunal in the period of 60 days. Voluntary undertaking, as I mentioned, the board may accept a voluntary undertaking regarding compliance from any person at any stage. So what is next? Okay, what is our way forward for our privacy readiness? So data fiduciaries as the organization, data processors who process the data may leverage Deloitte's expertise in the journey towards the compliance. We have a wide range of data privacy offering based on the tried and tested methodologies available with us to ensure the smooth transition for a privacy operating model. So what we typically do is a privacy compliance readiness assessment, and we develop a framework, and we ensure the policy documentation, inventory, data flows, personal data classifications are taken care, and any privacy notifications that we listed on the websites or the mobile for the data collection, which could be in the form of the notices. So we will do the assessment and will ensure that those privacy notices are taken care. The third party are the vendors privacy risk assessment and contract reviews in terms of the data processor, with respect to the data processing. Consent management and data principal rights. Again, the individual rights with respect to the data subject access requests and the consent management with the preferences will be taken care. We'll ensure how it should be stored and how it should be maintained. Technical and security control assessment to ensure the technical capabilities for the data breaches, data loss and prevention notifications, and the privacy notifications are taken care. And the training and awareness for developing the culture of privacy, it is applicable within the organization and outside the organization as well. So as a mandatory requirement of the DPDP, the organization must have the compliance training and awareness within the organization as the first thing, and then it should also list all those privacy data collection on the websites on their privacy notices. So I'll take a pause here before I move on to the next one. Any questions that you guys have so far? I've run 6 minutes late on this call, but
no, it's good. Actually, since it's a very highly sensitive topic, time demanding topic, the more the time you spend, the better for the listeners. It's good. Thanks, Malik. You can keep proceeding on the show.
Okay, thank you. So we have put together some of the references for the data protection bill that was in past, right? So as I mentioned, the GDPR, which started in 2018, and the PDA Act, which we had formulated in 2019. What are the differences that we formed, right? So the data localization is not in the picture of the GDPR, but then the PDA Act, the Personal Data Protection Act, it was there. But then in the DPDP, which is the latest act, which has been removed. So what we don't have from GDPR to the DPDP, if you want to know the key differences of it, is records of processing activities, which is not there, which is not mandatory. Data flow diagrams, how you store your data, which is not mandatory, but you can always keep it as an optional within the organization. Data localization, again, if it's just not a mandatory requirement. Cross-border data transfer reference, which is mentioned while you are transferring the data outside the India. Special categories of personal data that has been listed out. So when we talk about the special categories of personal data, we talk about the personal information, which is your name, phone number, date of birth. When we talk about the sensitive personal information, it could be your age, ethnicity, your medical information, and others. So all those special categories of personal data that is not there here. Significant categories of data controllers and fiduciaries is applicable in the Data Protection Act while you are processing the data. And right to the data portability, which is not there in the DPDP, but it is there in the DPR. Right to nominate, which is something new, as I mentioned, when somebody is deceased. So there is somebody who can always be nominated to take care of their data, so that we address the data handled properly. And responsibilities and penalties for the data subject principle, which is part of the DPDP Act, which is not there as part of the GDPR. It is only the organization where take the toll, but in DPDP, there is an individual who will also take the toll for wrong submissions of it. The data breach timelines, that is not clearly mentioned, how soon you should be reporting that to the government body. However, you can certainly notify the data breach to the organization. Data principal write response time, which is not mentioned for any data subject rights request that is requested. For example, in GDPR, it is 7 days, right? But in DPDP, it is not mentioned how many days you should be responding to the individual, as in mentioned. So you cannot keep that for a longer period as well. Okay, that is all I had for the Data Protection Act. I'll stop here and ask if there are any questions that you may have. We'll be happy to take them, or if you want to get a detailed answer, you can send me those questions. We'll be happy to answer and send it back to you.
Participants, do you have any questions? Probably you could able to either type in the chat window or feel free to unmute and ask. Okay, I have a question, Murli. From now that you are showed a high level overview about the DP Act and its implication, what has to be done, everything.
Right.
Is there any way you get notifications or the legal notification from from Government of India when it's going to get into Act? Anything like that?
No, so that is still being processed.
Okay.
No, there's no clear information on that. So
Okay.
what I see is only about the Section 43A, which is IT Act published in 2000. After that, there's no update on the notifications, etc.
Okay. Second question is, with your experience, what is it kind of team composition within a customer place? You feel when they start to diagnose this act, and what are things that they have to do about going about in their implementation, not from a technology point of view, but from a consulting point of view.
So to answer that, so there are two ways of explaining it. One is, see, the quick response to when something that becomes legal is always quick, right? So people wanted to get an understanding of it, and then they wanted to start immediately and process it. And also when such thing comes in the media, so the individual also get a little panicky about, hey, my data is being processed in multiple places, and I have provided my data in XYZ places, and I wanted to figure that out, right? So those are two things, and how quickly it is shaping up in the industry right now. The response is little slow because the awareness at this age is not so, not so huge across the organization. It's only about, the act has been introduced, and now who is doing what and what should we do. And in one of our other client conversation, they were really asking, should we really appoint as a DPO within the organization, or should we really hire somebody as a contractor, right? So there are still ways of maybe figuring out things, and so the response is slow. And I think this may take about a year or two in order to get to the stage from your customer base standpoint.
Okay, got it. Participant, any other questions from your side? Okay, fine. I think we are going to also, since we have a very short time to give a session on how SAP is point of view on the GDPR and plus also on the Data Privacy Act. We will shortly conduct a session exclusive for on how SAP point of view, what are the solutions which is going to meet the requirements of SAP's customers, especially for the ERP, ECC plus S4 customers who are already in SAP. How SAP solution is going to meet the requirement. Okay, there have been a lot of inquiries, plus also a few companies have been very proactive in starting the implementation of few of the solutions. but given the interest of time, we just have 6 minutes. On this point of view, we'll at least take 30 to 45 minutes. Probably, I'm not sure how is our calendar, but very soon there'll be an exclusive invite for all the INDUS members on how SAP's point of view on the Data Privacy Act. That's it from our side for this session. We are giving 6 minutes back to you. At any time given time, please feel free to use the community webpage to ask questions. There's also a WhatsApp group that has been created. Feel free to exchange your thoughts, ideas on the finance areas. We'll be happy to support going forward. Thanks a lot. Once again, thank you, Murli, for giving this high-level session on the DP. Thank you.
Thank you so much. And
back,
I'm also going to put the link to the online platform here. If you're not already part of the platform, please do join. So the link to join the platform is on the chat. So if you're not already joined the platform, please do join.
And I think, Mukesh, you can also just brief about the mobile app. So it's not just a browser.
Yeah. So the same platform is also available as a mobile app, both for iOS and Android. You can download it and use it earlier as well.
Ritesh, Ritesh, I think we'll just check out whether, because we have, did you get?
Let me check, Ritesh.
Yeah.
Anyone else having any issues with
I
the
would encourage your finance team members to join. Okay, not just you, but feel free to ask your finance team members to enroll, because there will be a lot of sessions or a lot of material that's shared for particular for all the finance community. They could also learn and unlearn a lot of things.
Yeah,